Good morning and welcome to everyone. Want to welcome you today to our CLE on rent escrow actions. My name is Mariah Kruger. I'm the Housing Program Manager and Resource Attorney at Volunteer Lawyers Network. We're really excited because we have received money along with legal aid to increase the amount of rent escrow work that we do in Hennepin County. So with that increased funding, we also took a look at how we might encourage more attorneys to do rent escrow actions. And so what many of you have done is signed up through your law firms as a part of the More Representation Minneapolis initiative to take a certain number of rent escrow cases in 2019. And the first thing I want to do is thank you deeply from the bottom of my heart. I'm so pleased. We've had 17 firms sign up through the More Representation Minneapolis initiative, both to do eviction defense work and rent escrow work. So thank you for those folks who are here today and are part of that initiative. For those folks that aren't part of firms that are part of the initiative, that's great too. We love to work with individual people who want to do volunteer work. And I'll tell you, rent escrow cases are a great way to take on a full representation housing case if you're interested in doing that. Before I introduce our presenter, I just want to say a few more thank yous. I want to say a big thank you to Faegre Baker Daniels for hosting us today. I love working with Faegre Baker Daniels because it always makes things go so much more smoothly. Appreciative to Jody Boderman and Amy Nelson of Faegre Baker Daniels for assisting us here today. Also just want to let you know the bathrooms are out and just down the hall. Please sign in to get CLE credit for it. I need to have everybody sign in. So if you haven't done that, those sheets are either floating around or sign in on the way out. And then we also had copies of the PowerPoint presentation. I also want people to know that this CLE is going to be posted online on VLN's Housing Volunteer Resources website. So if you're interested in getting the PowerPoint presentation again later or seeing this again after you've taken a rent escrow case, that will certainly be a possibility. So with all of those introductions and thank yous, I want to introduce our speaker, Georgina Santos. And we're so pleased to have Georgina here today. Georgina used to work at Legal Aid, and while she was there, one of her areas of specialty was habitability work. She's a contract negotiator now with U.S. Bank, and we're pleased to have her come and share her expertise. So if you would please warmly, Georgina Santos.
Thanks, Mariah, and thank you everyone for being here today. I gotta lower it for me. I just want to echo Mariah and just thank you for taking the time to learn about rent escrow actions and for considering volunteering. I really hope that this presentation just helps you feel more empowered to take these cases. Really, at the end of the day, you're navigating tenants through a difficult and trying time, and they're relying on you just for guidance and your ability to help navigate them through what can be a somewhat daunting personal process. And so, again, thank you. And if you have questions, please save them for the end. We'll leave time for that. Gonna figure out how to advance my slides. Here we go. All right. So, some statutes that you should know. Basically, most of what you'll need to know will be in Chapter 504B. And I wanted to highlight just a couple of the most important ones. So 504B.001 discusses what can be considered violations. So what a court will deem as a violation of the covenants of habitability. A violation is what gives a tenant the ability to come to court and ask for relief. And another really important statute, 504B.161, covenants of the landlord. These are the covenants of habitability. These are the promises that a landlord makes to keep the premises in a habitable condition. And then the actual rent escrow statute, so this is where you'll find your procedure, you'll find your timeline, and you'll find the relief that you can get under the rent escrow action. That's all in 504B 3.85. And another thing to note is 385 also discusses counterclaims. And you'll see there's a little bit of strategy with filing rent escrows at play because rent escrow actions often become a race to the courthouse. A lot of times, we'll talk about it a little more later in the presentation, but a lot of times there's not a lot of differentiation between a rent escrow action and a eviction defense case. It kind of becomes a matter of timing. So that's just a preview for you that we're going to talk about that later. And then it's also important to note the defenses to a rent escrow action. These are what a landlord will raise to try and negate your client's claims. So it's pretty simple and obvious. The landlord will say, I already fixed this violation. It's the tenant's conduct that caused it, or the tenant wouldn't allow me access to the property to be able to fix the violation. So those are just things to note when you're thinking about these cases. Another interesting part about practicing in housing court, so Hennepin County and Ramsey County are special in that they have their own set of housing court rules that apply. You can find them in the Minnesota Rules of General Practice. They're the 600 series, so they're only in Hennepin and Ramsey County. And the interesting thing about them is that they apply where not inconsistent with the Minnesota Rules of Civil Procedure. And you'll see, so I just put Rule 601 because you all are attorneys and can look this up, but there's about 12, 13 of them. You'll see that these rules cause for a different pace of practice. So for example, Rule 610, motions can be brought at any time. It's a bit more of an informal, relaxed approach to civil procedure. It allows for, the pros of this, it allows for really fast relief for tenants, but I think for us who might be used to, the general civil litigation timeline, it can be quite fast and a little bit unpredictable. So it allows for flexibility and creativity, but that's just something to note when you're applying the calculus of trying these cases. So just note that these housing court rules do apply in Hennepin and Ramsey County. There are other proactive tenant actions. So when a tenant is having problems in their housing and they want to take action, do something about it, they're not just limited to rent escrow actions. There's an action called a tenant remedies action and an emergency tenant remedies action. And I just bring them up to highlight a couple differences, but I would urge you to not really get hung up on the distinctions. These are all these actions in 504B at the end of the day are meant to be tenant friendly. They're meant to help tenants access relief quickly. But I do want to highlight some differences between the rent escrow action, again in 504B 385, and the tenant remedies action. So the tenant remedies action was actually the first proactive way for tenants to affirmatively seek relief. That was enacted in the 1970s, and rent escrows were not enacted until around 1989. And the difference between the tenant remedies action and the rent escrow action is that, one, the filing fee for the tenant remedies action is quite higher. It's $324 compared to $70. Again, a lot of, if you're volunteering through VLN, many of your clients should qualify for an IFP waiver. So this is not necessarily something that you will consider, but it's just something to note. Also, service is a big thing. Under tenant remedies actions, you're to effect service under the rules of civil procedure, whereas rent escrows, again, they were designed to be very tenant friendly as long as the relief you're seeking is under $15,000, the court will serve it for you. So that's a nice bonus, again, because this rent escrow action was intended to help a pro se litigant get into court, get relief without the help of a lawyer. Of course, your presence is going to greatly enhance that tenant's chance of succeeding, of making sure that they fulfill the statutory requirements, but the overall design of this action was really to be accessible for everyone. The tenant remedies action isn't used, practically speaking, it's not used much anymore. I filed one when I was at Legal Aid because I was representing multi-unit buildings. It can be helpful if you're trying to represent a large group of tenants, a more group-oriented action. You can incorporate a neighborhood organization and represent them. But really, for individualized representation of tenants, the rent escrow action is your best bet. So know that there's a tenant remedies action, but don't get hung up on that distinction. The emergency tenant remedies action, however, is something you might run into. And an emergency tenant remedies action is handy when you are trying to advise a tenant who is facing a really dire habitability issue. So lack of heat, lack of running water, no electricity, the ceiling is caving in. I have run into that one before. So when you get those types of issues, condemnation is another one, you might want to think about advising about the emergency tenant remedies action. Procedurally very similar to the rent escrow action, but the biggest distinction is that there isn't a written notice requirement. All you have to do is tell the landlord 24 hours before you intend to file that you'll be seeking this relief. So what I used to advise tenants is to say, you know, be specific about the problem that they're having. I'm having raw sewage in my basement. If you don't come and take action to try and fix the issue, I will be going to court and filing an emergency tenant remedies action. And that notice doesn't have to be written. They can call the landlord. The court, once they apply, by filling out an emergency tenant remedies action petition, once they apply, the court will usually grant the emergency relief, so mandate that the landlord has to fix whatever issue is going on. And then the court will set it for a hearing about a week or so out. But again, this emergency tenant remedies action is designed for a very specific set of very serious habitability problems, and it's designed to get tenants relief very quickly. Unfortunately, if the tenant's problem doesn't really fit this, short description, I would still say that filing a regular rent escrow action that requires 14-day written notice is probably your safest bet to avoid dismissal. But you should be aware, for those types of problems, there is a quicker option. So back to the rent escrow action. So you have a tenant and they're telling you that they are having a lot of repair problems in their property. And so I wanted to just bring up some points you should consider when you're investigating your case, and then some considerations. So a lot of factors impact the strength of a rent escrow case. The types of repairs, how severe they are, and if a tenant can live with them. I mean, really, if a tenant is in a position where maybe it wouldn't qualify for an emergency repair, but let's say it's a severe severe infestation of vermin, and they're not really able to wait out any kind of timeline. They can't wait 2 weeks. You might think about not advising the litigation route, or if a tenant is really not able to wait out the repair issue, that's just something to consider. Another factor when you're investigating the case is finding out if the tenant has attempted repairs themselves. And I bring this up only because it can tie into a defense that the landlord may try and raise if you were to later try it. A lot of times landlord will say, you know, that this attempted self-help, the fact that they sprayed Raid actually scattered the cockroaches and made the problem worse. So it's just actually the tenant's misconduct that's causing this issue. So it's important to know if your tenant has attempted repairs, that's not, you know, a red flag, do not file this rent escrow, but it's a way for you to pause and say, oh, I need to figure out what self-help you've attempted, what were the measures, how you did it, did you follow the instructions on the package? This should trigger to you to ask a few more questions. And the other thing that's helpful is finding out what documentation the client has of the repair problems, because this documentation is really powerful for a court when they're considering the type of relief to award. We'll touch on that later. But does your client have pictures? Does your client have receipts for the furniture they had to purchase because of the bed bug infestation or the mold? Asking for really everything that a client has related to the repair problems can be very helpful for you to get a holistic picture of your case. Another important thing to know, a resource for you all, is 311. So if you call 311 or direct your client to call 311, you can follow up with the City of Minneapolis to have them request an expedited inspection. This can be helpful because city inspections can serve as the 14-day written notice. When a client hasn't written notice themselves, you're not in the position to write the notice for the client. This can be helpful. Also, sometimes a city inspector can provide a set of expert eyes on a repair issue. So this can be a really important tool as you're investigating your case, is what does the city think of this property? I'll talk a little bit more later about how this is sort of a two-edged sword, but I would make note that you have that ability. These two individuals can go out to a property and inspect it on a short notice. So speaking of notice, I mentioned earlier that in order to get relief under the rent escrow action, you need to provide 14 days written notice to the landlord. The landlord needs to know these are the problems this tenant's bringing up. This is what they're requesting be fixed. The ideal situation, of course, is that you as the lawyer write the letter, simply because it will help you. It's the start of your case. That's really how you should look at it. It'll allow you to frame the issues and have a sense of everything that you're wanting to potentially put forward before the court. Notice must be delivered personally, so having the tenant give it to the landlord or sent to the place where rent is normally paid. I've seen rent escrows tried over text message, but I don't think that necessarily follows statute, so I would urge just to follow what statute says and to write a letter. Tenants can also write a letter, but I've found that it is sometimes really effective, and sometimes that's where your case stops. A well-written letter that identifies the issues and lets a landlord know that, this is a serious situation, that this tenant is serious about seeking relief if needed. That can be a very powerful deterrent. So just note that that is a really great opportunity sometimes to affect change for a tenant. The other issue is rent money. So when you're investigating your case, you should ask your tenant if they owe an arrearage. And the reason is sometimes when there's rent owed, even though there are repair problems, a landlord will want to file an eviction for non-payment of rent. And evictions are on a record from the moment that they're filed. So even though later there's an eviction case and the tenant brings up meritorious defenses and later prevails, the entire time that this litigation is going on, that tenant has an eviction on their record. So if they want to apply to new apartments, good luck. So it really becomes, this is what I mentioned earlier, it becomes sometimes a race to the courthouse when there are repair problems, because tenants, I mean, it's everyone's natural inclination. I'm paying money for a place to live that's safe and habitable, and this landlord isn't providing that to me, so I will not pay that money. I tell tenants all the time, the fact that you're withholding, it makes sense. However, it puts you in a position where a landlord might file an eviction action against you anyway, because if you're a day late and $1 short in Minnesota, that would give the landlord cause to file. Will the tenant have defenses? Yes, but practically speaking, the fact that the eviction is on the tenant's record can just be so harmful to somebody who's just trying to find housing that it's best if you can take proactive action and try and get that rent escrow filed before a landlord files for non-payment of rent. So that's what I said, how sometimes that distinction between an eviction defense and a rent escrow, it's a thin line, and it can become a race to the courthouse. So that's just something that you should know about, any potential arrearages, not just for rent, but also utilities, because utilities, sometimes landlords will file that as a breach of lease, because in the lease, the tenant agrees, hey, I'll pay these utilities. Tenant, there's a leak, water leak in the basement, water bill is sky high. Tenant's mad because their water bill, even though they're supposed to pay it, it's really high, and it's because it's a leak that the landlord's supposed to fix and still hasn't fixed. But that arrearage just should be something that you note, because it's a potential liability for your client. So just part of the calculus when investigating your case. Uh-huh. Yes, that's a great question, and we can touch on that. Yes, you would ask, part of the relief you can ask for is an expungement. So yeah, if you prevail, absolutely ask for an expungement. The difficult part is during litigation, it's on their record, and sometimes it can take a while. We'll get into that later, but basically, so the timeline, tenant comes to you with problems, you write the letter, 14 days pass, no actions taken, you file, first appearance like a week later, no settlement at first appearance, you're in trial, trial set probably a week after first appearance, and then after trial, the court has up to 90 days to make its decision. So during that entire time, there's an eviction on the tenant's record. So it's unfortunately just a part of the calculus that you do when you're taking these cases. But yeah, it's absolutely something that can be overcome, but you just have to prepare your client for it.
So from filing to the time of court, 120 days?
Yeah, ish.
And then, Georgina, because we're videotaping and there's not microphones in the audience, would you repeat the question?
Oh yeah. So the question was, thank you, Mariah. The question was, can a tenant's record, can the eviction be removed from a tenant's record as part of the relief? And yes, but practically speaking, just as I said, there's just challenges sometimes with that. So some other considerations. I mentioned earlier that 504B 385 lists counterclaims, and the counterclaims is a counterclaim for possession. 385 gives the landlord the ability, so within the rent escrow statute, the landlord has the ability to file a counterclaim. And this means that your rent escrow could actually become a vehicle for a landlord to file an eviction rather cheaply for only $77. I think the current filing fee for landlords is $299, so that's a really great deal to me. We talked about that race to the courthouse aspect. This is something that I think some really smart landlords know, that if they just wait and their litigious tenant decides to file a rent escrow, well, great, I'm going to counterclaim for possession based on non-payment of rent, based on breach of lease, whatever they have, and I'm going to get to file it for $77. So that's just something you might just want to, yes.
So if they do that counterclaim, will that similarly show up in record while that person is looking for a new place to live, as it would if he just independently filed an eviction action?
Great question. So the question is, if the landlord counterclaims, will that show up on the tenant's record, like if they had filed for an eviction action? So yes, but it'll show up as a rent escrow, which is why even though, yes, filing the rent escrow could expose your tenant to loss of the property and eviction through the counterclaim. Record-wise, it'll show up as a rent escrow action. There are some landlords who do their background checks by going down to the Hennepin County Courthouse and manually clicking and running clients' names, and they'll see, oh, this client filed a rent escrow. I don't know how that would work as far as denying rental, but that's a tangent we'll get on. But no, it is better. That's why it is better to be able to file first, because it'll show up as a rent escrow instead of an eviction. And yeah, a potential landlord could see that there was a counterclaim filed, but the actual, it won't show up as an actual eviction. So that is that's the plus. Some other considerations are that as I mentioned earlier, some repair issues are really very severe and clients just need or want to move. And so, rent escrows are really great tools, and we'll go on later to talk about the benefits, but they're not a one-size-fits-all. And for some situations, it's just not what that client wants or needs. So if it's a situation where the client just isn't able to wait maybe that 120 days, potentially, it's just something to note for them. Deferred maintenance and complex repair issues can be really difficult to present to a court. A lot of my multi-unit cases were cases where buildings were just, owners just didn't maintain them, and they got passed from owner to owner, and they have like long-standing problems, water intrusion, mold, pests because of that water intrusion and mold. And it can be hard to, pin the liability on the newest owner. So that's just when you're talking to clients, when you're thinking about cases, that's something that you'll want to think about and investigate. And you should prioritize the issues that you file on. Clients, these covenants of habitability I mentioned in 504B161, you can't waive them. You can't waive them in contract. They don't go away. So you can prioritize the issues. If there are a lot of severe water intrusion, electrical problems, but client's also really mad about a hole in the kitchen that's cosmetic, and you're deciding what to file, it'll be part of the calculus. That's just, I want to note that for you. And then, like I mentioned earlier, there's a potential you can beat a landlord to filing to keep the eviction off of a client's record. The other thing to consider is, can the client post rent while the case is decided? So for rent escrows, clients have to escrow their rent. They have to post the amount of rent into court while the case is being decided. And because a court has 90 days to make the decision, you should prepare a client for posting their rent, so going to Hennepin County Housing Court and paying their rent while the case is decided. And for some clients, getting rent together on the 1st is not possible. So it's very important that you have a frank discussion with your client about when they pay the rent, how they pay the rent, and if they can pay it on time, because if the rent is not posted, so the court will order, we'll go into this later, I feel like I'm a little bit everywhere, but during usually the first appearance in the rent escrow case, the court will post an order dictating when rent is supposed to be paid. Usually at that time I would pipe up, knowing if, for example, my client has certain sources of income that don't pay out till the 3rd, to ask for like the 5th business day of the month or the 5th of the month, and being very careful about the time of day, because maybe a client has a job, can't get off, needs until 4 p.m., can't pay at noon, because sometimes the court's default might be the pay the rent by the 1st at noon, and there's just no way that a client will be able to do that. So try and find out really the nuts and bolts of how the rent is paid so that you can ask the court for a time and a schedule that really works for the client. Because if the client doesn't pay rent the way that the court dictates, the case will be dismissed. And I have a example of this. I did a rent escrow November of last year, and I believe the court ordered posting. I think it was on the 1st at noon. And I had just told the client, hey, pay the rent by the 1st, and gave her the order, that said by noon. And she called me at 1 p.m. from Hennepin County Housing Court and said, I have the rent, but they're not accepting it. They're telling me the case is going to be dismissed. And so I had to file and write a letter to the court, all this, get it figured out. She was eventually allowed to post, but it was a situation where, these are not orders where there's a lot of room for error. The court's not like a landlord. Well, they'll just that's kind of one of the downsides. The court doesn't have flexibility. So it's really important that you find that out just to set the client up for success. But luckily, you have resources, and one of those resources is potentially the habitability fund. So the habitability fund is a fund that provides clients with access to money so they can pay rent into court in order to pursue cases like rent escrows or to assert habitability defenses in an eviction action. The funding for this is from the McKnight Foundation, and it's administered by VLN as long as the client's address is in Minneapolis. The client is likely eligible, and the amount is determined. You should talk to, if you have a case where you think that the habitability fund might be necessary to help a client just get over that, hump to be able to post, you should talk to Mariah to discuss the availability of this fund. And it just should be clear, there's it's part of the retainer agreements and everything you sign with clients if they're going to use this fund. It just makes clear that if you win rent abatement, the rent abatement the client wins would first go to reimburse the fund, and then any remaining amount would go towards the client. So it's just something to note that you have available to you should you have a client who just can't get into court due to the inability to post that amount of rent. So talk to Mariah because this is something that VLN administers. So setting client expectations is a really important part of this whole process, I think. I think the biggest misconception I think sometimes about rent escrows is that they're about money. And really, their primary usefulness is repairs. To get a landlord who hasn't been doing any repairs to act. They can be trickier tools when you have a landlord that's slow or not making great repairs. But if you have a landlord that's not making any repairs at all, this is a great tool, but really these cases are about repairs and not rent abatement. 504B425 sets out the kind of relief that's available under these cases, and it gives the court wide discretion to award abatement. So it means that rent abatement can be all over the map. So I would definitely underpromise to a client when it comes to rent abatement, just so that they're prepared. Other issues so I say other issues will not necessarily be part of the case. So unfortunately, when you have a client with repair problems, there's a lot of other problems that sometimes tend to be co-occurring. Like this is obviously when you're thinking of suing your landlord, it's a damaged relationship. Maybe there's a landlord and tenant just don't get along, a little bit of bad blood there. sometimes just tenants don't feel respect. I mean, I think that's a lot of it is tenants don't feel respected when they're renting a place and a landlord is not making repairs despite tenants asking. They don't feel like they're being heard, and so I think that sometimes it can escalate a lot of other issues. And so having to keep the client just focused on the fact that this is really going to be about repairs and letting a court hear the problems that you've been having, and really the overall goal will be physical improvements to the property. Another thing to note is that if a landlord made a reasonable attempt at repair, a tenant might not recover damages to personal property. There's a Court of Appeals case where a landlord offered a chemical and a heat treatment for bed bugs, a chemical treatment for bed bugs, but the clients wanted a heat treatment because it's in many ways more effective than a chemical treatment, but the landlord opted for a chemical treatment. A lot of the client's personal property was damaged, and the court held that the client couldn't recover for that loss of personal property because the landlord made a reasonable attempt at repair. So even though it wasn't a type of repair that would have also spared the client's property, it resulted in the client being unable to recover. So that's something else to note. Just when, clients bring up, hey, I had to buy new furniture. I ask for it anyway sometimes, but if there were reasonable attempts at repair, it might not be recoverable. But usually, I had a bed bug case where a client lost a lot of furniture. It's really rare that a client's going to lose furniture and there's a reasonable attempt at repair. Another thing clients should be aware of is that their lives will be put on trial in these cases. A lot of the defenses that landlords have will necessarily raise issues that the client, imply that the client's dirty or that they, caused it or that they like living with pests and vermin, and it can be very personal. I mean, these are personal cases. This is someone's home and the condition of someone's home, and there's no way that they're not personal. And I think just preparing a client for that they're going to have to sit in court and not react when a landlord calls witness after witness to say, oh, yep, the client just lives like this, and this is their life, and they caused it. It can be really difficult. So it's just a conversation to have with clients that's going to be part of this, and that you'll support them, and that the landlord litigating your case this way might not have legal merit, but it will likely happen. And that these cases can take a long time. 90 days is the outer limit. I'd say that courts recognize that these cases involve real people living with real problems and try and get decisions out in a timely manner. But I mean, there are thousands of housing cases in Hennepin County. Court dockets are very full, and it's just part of the process. And so it's something to note with clients. And then another important and sometimes challenging conversation is just defining the scope of your representation and when it will end, because as part of these cases, sometimes it might be necessary, especially if repairs are ordered. It's good practice to ask the court for a compliance hearing after a certain amount of time. And then, at that compliance hearing, if repairs aren't addressed, what do you do now? And how long you'll be part of the case, and for you and the client defining what a fix, a repair looks like. I think that's important. So that should be part of how you assess the case, how you talk to the client, is figuring out definitively, I'm going to be in this case when X happens, when it looks like this. It can be a difficult thing to measure, and again, feel free to reach out to the resources at VLN to help you navigate that conversation with clients. So I feel like I've talked a lot about the challenges that come with filing rent escrows, but I do want to spend some time highlighting why we should file these cases, why they're helpful tools for tenants. I mean, like I said before, these are intended to be friendly to pro se litigants. They're intended to be fast. There is an inherent deterrent power in them. You know, landlords have to take time off and be in court. And it can be when the power dynamic between a landlord and tenant is such, it can be just a very affirming act for a tenant to have their voice heard in court. So there's a real, oh, sorry. Great, sorry. I hope everyone can hear me. So there's a real value to that. And again, if the overall goal of these cases is to improve the housing stock in Minneapolis, this can be a helpful way to do that. So even though maybe the client moves after a certain time, or not every repair is done, you should also think about the incremental improvements that you can get to a property, and just knowing that a property that had deferred maintenance now doesn't. So in my multi-unit buildings, was everything fixed? No, but there are no more rotting vanities in all the bathrooms. The fans work. And so, you know, my clients had their, you know, their lease terms there. And if they decide to move, I know that for the next tenants, they will have the advantage of being in a building where the conditions are that much better. So that's something to really think about. So timing when to file. So filing, you have to wait till after your 14-day notice has expired, and that means the repairs have not been resolved. And you know, the cleanest and easiest way is when no repairs have been attempted. Sometimes when repairs are attempted, depending on how your client's feeling about it, you may want to grant the landlord an extension. You can talk about it, but a case essentially is ripe after that notice has expired. Remember that notice can also come in the form of a city order. So meaning a city inspector ordered the landlord to make repairs. And sometimes that order has expired. You should note, though, that the expiration of an order doesn't necessarily mean that the city's been back out to re-inspect. The other thing about city orders is that the ordinances set a minimum standard for habitability, and the city inspector's charge is to look for compliance with that minimum standard. And it's my interpretation that that minimum standard does not actually equate to the standard in 161, the covenants of habitability, not necessarily. So the city might say something is fixed, but that doesn't mean that your client does not have a case. It doesn't mean that the issue's resolved. So the city orders can be helpful evidence. Subpoenaing a city inspector can be a really powerful, they can be a powerful witness, but just to note that city orders don't necessarily, they're not the end all be all. It's a tool and a resource for you, but at the end of the day, sometimes more investigation is needed. It's always helpful if there's a city inspector involved, if you can get in contact with them, just to get a sense of what they think about the property. And 311 can be another tool for you to get a physical copy of that repair order, because they're not like posted online anywhere. You can also have your client go down to the public services building on 4th, but I find that sometimes me calling and just asking for an order or emailing the inspector and asking for a copy of the order is the fastest way to get that. So the first thing you'll do when filing is preparing the actual rent escrow affidavit. And I believe VLN has copies of the rent escrow affidavit if you'd like to actually see what the physical paperwork you'll be preparing is. But when you file it, you should, if your client qualifies for a fee waiver, that IFP affidavit should be filled out and signed. If you need help figuring that out, please contact VLN for guidance. And then when you're filling out the affidavit, it asks for really basic information like who the tenant is, where they live, who the landlord is, who the management company is. And then it'll ask for a description of the repair problems and the amount that the tenant thinks it will take to actually fix the repair problem. And as I mentioned earlier, if it's under $15,000, if your prayer for relief is under $15,000, the court will serve it for you. So you should use your best judgment in figuring out really how much. I just recently became a homeowner, and I realized how I was really undervaluing the cost of repairs. But I would say talk to the client, use your best judgment, and just be aware of that jurisdictional limit, because if you ask for over $15,000, you'll have to effect service formally using the rules of civil procedure, and the court won't be able to serve it for you. And then the big question when you're preparing the affidavit, so again, it's the basics, about the property, describing the repairs, and then asking for relief. And part of the relief is obviously please fix everything in the list above. And then you can ask for rent abatement. And how much to ask is always kind of an interesting question. Some people, some of my colleagues at Legal Aid would use sort of like a formula that they would present to the court to try and justify their rent abatement ask. So the number of rooms and probably weighing a little bit more if it was like a kitchen or bathroom, less for a bedroom, taking account square footage, but really just think about all these different factors and just make a call that you feel that you can support. It's not an exact science, and I think my best advice is to find old housing court cases that you can use as persuasive authority for the housing court referee. So VLN will have access to those. I'll have some resources up later where you can find that, but those old housing court cases can help the referee decide, hey, this is what other referees had decided in the past. So here's some maybe guidelines or considerations when you're thinking about rent abatement. But I always highlight to the referee how they have a lot of discretion to award that rent abatement. So I wish I had more guidance for you, like a helpful formula, but I would say just use your best judgment in valuing the amount of rent abatement, how much your client's been harmed. I usually ask for quite a bit and let the client know that we might not get that much. For example, I had a case with, it came to me because the client's 1-year-old had elevated blood lead levels because the landlord had failed to do lead abatement as mandated by the city. And there were severe repair problems. The city inspection orders were actually in that case very helpful. And I asked for, I think, 100% rent abatement going all the way back to the start of the lease because my client had a list that she made the landlord. So, when you do your move-in inspections for renting, very helpful. If your client has that, that's gold for trying to prove that these problems have existed since the beginning and that the landlord has had notice of them. But I had that case where that happened. And it ended up being, because the case was an eviction, the court only awarded 100% abatement from when the eviction was filed, not going all the way back. So it only ended up being like 3 months at 100% abatement. But those were pretty severe repair conditions. That's just an example to you that these cases, like the court focused on ordering the repairs and making improvements to the property. And the landlord had to comply with all the lead abatement orders with the city. And all of these things had to be fixed. But in terms of money, not a great case. It's not a windfall for the client. So that's just something to note. Timeline. So we talked about that earlier. But again, so once you file the rent escrow, the first appearance will be 10 to 14 days. Maybe it's 7 to 10, I forget. There's a slight difference between rent escrows and tenant remedies actions, but it's a quick turnaround. So about a week. is what you should prepare you and your client for. And your first appearance is a chance. It's just during the docket, the first appearance docket, usually with all the other eviction cases. And the first thing that is done after roll is taken is that the litigants are ordered out into the hall or the mediation rooms, and they're ordered to try and settle. And so you'll do that. And then if you're unable to come to a settlement, meaning getting the landlord to agree to do repairs at a certain time, agree to certain rent abatement, allow the client out of the lease for some money, whatever you and the client decide. If you can't get that, you'll go before the court, report to the court the status. Court will set a date for trial and usually talk about posting rent. And this is where I told you should be prepared with nuts and bolts for how to set your client up so they can post rent successfully. And then another thing you should do is ask for, so discovery is informal. When you read the housing court rules, discovery is informal, and you should ask for informal discovery at that time. Usually I just write a letter to the landlord, and you should ask for the ability to, I like to see all the maintenance records, anything you think that would be helpful for the case that you would be able to, obviously within reason, pursuant to the rules of procedure and evidence, but it's at that time that you should ask the court that informal discovery be ordered. And then I usually, after I walk out of court, I hand the landlord the letter saying, here's some items I'd like, and usually the discovery is due like 2 days before trial. So you have a little bit of time to sort through it. And I also ask for a copy of the landlord's exhibits, and you should also be prepared to give the landlord a copy of your exhibits. It's best to come to court with about three copies of all your exhibits. For trial, it's best practice to subpoena your witnesses still, even though it's housing court. I like to do slideshows or binders of pictures. Again, it's just really helpful to keep all the repair problems organized because there can be just so many in a property. And sometimes when if you're representing, let's say, a few clients in a multi-unit building, having like a chart, just something to organize everything, it's really helpful for the referee. As I mentioned earlier, the housing court rules affect the pace of trial. So bringing pictures, bringing tangible evidence, you'll hear different schools of thought on this. There are some attorneys I've heard that will actually bag the vermin or bring a jar of raw sewage just to really drive it home. I would use your discretion on that, but just note that that has been practiced before. I did not do that. I've always tried my cases with pictures. I found that to be compelling evidence. Consider calling experts, and if you get to that point where you have like a big, vermin issue or mold issue, VLN, legal aid, we know of a few experts that will be able to testify to those kinds of issues that can be so helpful, especially in cases where there's like complex, big vermin problems. It's a long-standing problem. So just note that those tools are still available to you in housing court. So the issues after trial, again, rent's got to be posted as ordered or you would risk dismissal. Sometimes there's just some administrative difficulties when you have two adverse parties still having to interact with each other regularly because landlords have to schedule time for repairs. So just prepping your client that landlords need to give reasonable notice and you should ask for that, but probably err on the side of granting access to a landlord and be prepared for a landlord coming in and trying to repair these issues. And then knowing that a client might move during your timeline, that happens from time to time, but again, it shouldn't affect your case in terms of the repairs or rent abatement or relief. It's just that your client won't benefit from living in a house with the repairs or apartment with repairs. So just some resources for you. I'm running low on time, but encourage you to watch your first appearance calendar. The Minnesota Department of Health is really great. If you want to know more about mold, bed bugs, any of those kinds of issues, they're great resources. And these can be helpful for you when you ask questions of clients about these types of repair problems. The city's got great resources on their website as well. And then I list some other helpful websites. And then, of course, you have resources at VLN. And we're I know that everyone here, we're really excited about the More Representation Minneapolis initiative. And thank you for your time and your willingness to be a voice for tenants here in Hennepin County. All right, with that, questions?
I have a number of them. First of all, in terms of expert witnesses, does VLN have resources to pay these expert witnesses? No. So do they do it on a volunteer basis, or are the firms expected to put the expense?
Something that would have to be figured out.
Okay.
And if you want to repeat that.
Yes. So, are there funds for expert witnesses? Does VLN have funds for expert witnesses? No, that'd be something that would have to be figured out beforehand. If an expert can volunteer their time, or if a firm would be able to cover the expense. But no, that'd be a question to talk about and deal with beforehand.
Regarding the looser rules in housing court, I'm used to administrative cases. Is hearsay accepted in housing court or not?
No. Rules of evidence still apply.
Okay. Then you talked a lot about Minneapolis. What would be the comparable, like 311 for somebody in St. Paul? Who does those inspections in St. Paul? Okay.
I don't know. So the question is St. Paul. I mean, the St. Paul has the Department of, it's called DSI is the nickname, but they have a city housing inspections department.
Okay. And then we were talking about the landlord's counterclaim. But if rent is paid in the amount ordered by the court, how can the landlord maintain a counterclaim for possession?
Usually there's a lot of back rent owed, so the client would either have to post that whole amount of back rent owed, or the landlord's claim would be based on like amounts from before that previous month. So the question was, if a client has to post rent into court, how can a landlord maintain a counterclaim? The way I've seen it is usually it's clients owe a very large amount of money that they won't be able to come up with to actually post the rent. And so it kind of becomes a deterrent to filing a rent escrow at times. And so that's where the litigation fund can come in if you have really strong habitability claims and you think you can maybe win that back in abatement. But yeah, it becomes very tricky. Yes.
I wonder if you have any experience or thoughts where one side or the other might ask that a judge hear the case or try it before a jury?
Yeah, so rent escrow actions, unfortunately, and tenant remedies actions, there's no right to a jury trial, but eviction cases, you do. So that, again, these cases, like I said, very thin line. These can be very compelling jury trials. So yeah, that is available to you if you want to do this as an eviction and raise the tenant's repair problems as a defense to an eviction action. I don't think I answered your question fully, though. There was another.
Wondered if you had any experience with that or thoughts on when, one side or the other might go that route.
It's happened. I haven't personally tried a jury trial in housing court. I have asked, so you get a right to remove a judicial officer so long as you file before the first appearance. And it's been cases, there's only 2 referees in Hennepin court, housing court, and I've removed a referee, and then the landlord's attorney has removed a referee, and so when there are no other referees, they put the case before a judge. And usually when I remove someone, I know that the other side will likely remove, and I know then it'll be tried before a judge. And the thing about trying it before a judge, one of the benefits about trying in housing court is you have a referee who's seen a lot of these cases, really familiar. But also, if you try it before a judge, you'll have fresh eyes, someone who hasn't necessarily seen these issues every day. So there can be benefits in terms of that forum. But yeah. that's just something to note when you're thinking about these cases. Yes.
If you prevail, are landlords publicly sanctioned or at least in some kind of documentation?
I'm sorry.
Is there any kind of sanctions against the landlords?
Oh, sanctions against the landlord for rent escrows. I mean, like public. So I guess, I mean, they're ordered to make repairs. They
The tier system.
Oh yeah, the tiering system, yeah, is a potential sanction. The city of Minneapolis ranks rental properties by tiers. And so sometimes if there's a record of a landlord's property being in a poor condition, that'll affect the tiering, and that's publicly available. So that can be a deterrent. You can ask for fines as part of the relief. In addition to rent abatement, if the landlord fails to comply. 425 has there's a lot of judicial discretion. So yeah, but no, that's a great question. I really can't think of anything else. I feel like there was another hand. Yes.
How do you deal with the situation where your client succeeds, they're ordered to make repairs, but the landlord complies with some repairs, doesn't comply with others?
That's a great question. How do you deal with a situation where client prevails, repairs are ordered, only some repairs are actually done, compliance hearing. So asking, usually after I close, I will let the court know I'd like a compliance hearing at a certain date if we prevail. So I would ask for that. So prepare for that and make it part of your initial presentation of the case. And like I said, though, it can be tricky then to find out when your representation ends. So that's something to really investigate all those issues and talk to your client beforehand. All right. If you have any other questions, please feel free to write any of us an email. Thank you so much for being here.
And thank you so much, Georgina, for coming and speaking with us. Thank you to all of you for attending. I do have the CLE numbers on the sign-in sheet. We've gotten one standard credit. Once again, thank you to Faegre Baker Daniels for hosting. We appreciate it. Also, if there are those of you who are interested in getting signed up to take a rent escrow case now, I have a yellow tablet right there. And if you just want to sign your name on that, we'll try to contact you before the holidays here with the case. And my card is there if anyone has any other questions. So thank you again for coming.